as the strike by the Academic Staff Union of Universities enters the 9th month. The Minister for Labour and Productivity, Ngige, has given certificates of recognition to 2 parallel university teachers' unions. The Congress of Nigerian University Academics, known as CONUA, and the Nigerian Association of Medical and Dental Lecturers in Academics, known as NAMDA. Here is
the Congress of Nigerian University Academics, CONUA. CONUA applied for registration since 2018 and cited irreconcilable differences with ASUU, as their members do not believe in recurring recrudescent strikes as the solution to every welfare agitation. They also accuse the ASUU executive of non-rendition of accounts of incomes and expenditure for years. And in one of your letters, they asked for the removal of their check-off dues from ASUU. And in one instance, wrote to the Accountant General of the Federation directly with this request. When this agitation became increasingly very serious, the Ministry of Labour and Employment set up a committee to look into the merit of the application. The committee saw merit in this application, recommended approval for the registration of the association by the Registry of Trade Unions, RTU, since 2019. But for the advent of COVID-19 in 2020, this would have been done. This was also not helped by the fact that ASUU also went on strike in that same 2020, while COVID-19 was on. And the ministry felt that the registration at that time would be interpreted by all and sundry as we shunt. The second association is the Nigerian Association of Medical and Dental Lecturers in Academics, NAMDA. Like their colleagues in CONUA, they had applied for registration as medical teachers in the university system, but they applied under various groups.
In a separate development, but with considerable judicial consequence, the Rivers State House of Assembly has passed a motion to derecognize Celestine Umehia as a former governor of the state. Umehia was governor of Rivers State from May 29, 2007 to October 25, 2007. His election was annulled by the Supreme Court, while Rotimi Amechi, Minister of Transportation, was declared the winner of the state governorship election. Despite the Supreme Court judgment, Umehia was recognized as a former governor of the state by Nyesom Wike, the incumbent governor, and also the State House of Assembly in 2015, and it was accorded all entitlements. Abiodun Jalili Owonikoko is a senior lawyer and a senior advocate of Nigeria, and he now joins us for his thoughts on these 2 major issues during the week. Ejo Owonikoko, very good to have you on the program. Thank you for joining us on This Day Live, the Sunday Talk Show. Can you hear me?
Good afternoon, Dr. Ruben Abati. It's my pleasure to be with you on this very cold and friendly afternoon.
Okay, thank you very much for joining us. Okay, where do I start from? We have 2 major issues now. One is the ASUU matter. The other one is the matter in Rivers State. But let me start with ASUU. In the matter of ASUU, the lead judgment by Sir George Well indicated that yes, ASUU has the right of appeal, and that the right of appeal is both constitutional and statutory. And in this particular case, the Court of Appeal has exercised its discretion to say that the Court of First Instance, the National Industrial Court, in granting the interlocutory injunction was, acting properly. And the court then ruled that one, ASUU, the Academic Staff Union of Universities, must first of all respect the ruling of the Court of First Instance, namely the National Industrial Court. And going further, they have 7 days within which to obey that ruling. And going further, if the academic staff of Union of Universities ASUU fails, then they will not have any recourse to any appeal, because appeal, the right of appeal, under the appellate system that we have in the judicial system in Nigeria, is both constitutional and statutory, and in this particular case, it is discretionary. What are your thoughts?
Thank you so very much. I have had a very comforting opportunity to read the ruling of my Lord Justice George with respect to the application by ASUU for leave to appeal. And I must say to you that it's one of the most cerebral and also pragmatic judicial decision I've seen coming out of our court in recent times. It has all the trappings of Solomonic wisdom, because the court ultimately addresses the interests of not only direct combatants or disputants, but the larger society. The biggest victim of the ASUU strike so far has been the students in our public institutions of higher learning and their parents. What led to the crisis itself is not as important as what it has cost in looking for a solution. We have to understand that ordinarily, until the case of Stanbic and ASUU, there was no right of appeal from any decision of National Industrial Court in respect of trade disputes. And the only limit to that restriction was with respect to breach of fundamental rights. There was even no right of appeal with leave of court. But Supreme Court was invited to look at the Constitutional Provision 254C of the Third Alteration that was enacted in 2011 and came to the decision that the provision that the NIC decisions can only be appealable outside of those enumerated items with leave of Court of Appeal did not require that a new law be enacted, entitling Court of Appeal to grant leave, but that their general powers of granting leave would suffice. I think that's what the ASUU had attempted to explore in approaching the Court of Appeal. However, the question whether Industrial Court or National Industrial Court or Industrial Arbitration Panel can entertain a trade dispute during the pendency of an ongoing industrial action is not a novel point. It has always been the practice, backed by law, that before either the IAP or NIC will enter upon adjudicating any trade dispute, both parties must cease industrial action. That is, if the workers are the one on strike, or if the employers are the one that are locking out, they must suspend it and then allow the court to assume jurisdiction. So, it's not strange, given where the jurisprudence of labor law has been going in recent times, that the Court of Appeal found it imperative to exercise its discretion with caution, because they have very limited window within it to interfere with the decision of the National Industrial Court. Its decisions still remain final and unappealable, except for very, very rare circumstances. In this case, people should understand there is a recognition of power of workers to go on strike, but it is not a right It is an instrument for enforcing a right. So when we go back to the brass tacks, the issue here is not about strike. The issue here is a dispute between ASUU and the federal government with regards to the conditions of work in the universities. So the strike was just an instrument for parties to use to negotiate and bargain. And unfortunately, it now became the main issue between parties, and the real issue was put on the back burners. So I think that as matters stand, what the Court of Appeal has done is to grant a conditional leave to appeal subject to compliance by the trade union with the order earlier made by the National Industrial Court. And like I said, it's very unusual that you go to a court to validate what by law is not, supposed to avail you. Once you go to court, the issue of strike ought to cease temporarily, pending when the decision of the court is given. So in this instance, I believe that all parties' interests have been protected. The right of appeal with leave has not been denied. The interest of the public and the state has also not been trampled upon by ensuring that if they want to explore the right to appeal, it cannot be at the expense of the schools being shut down or the government being unable to address the more fundamental issues concerning the dispute between them. So I think it's a welcome development, and I hope that both parties will take benefit of this window to sort out their affairs, as the court indirectly admonished when the order was made. So I believe that as law-abiding, respected elites in society, the ASUU, despite their misgivings and disappointment, will at least show respect to the court and call off the strike pending when the outcome of their case is determined. Don't forget, a decision of the Court of Appeal on this matter is final forever. It's not appealable to the Supreme Court, because the Court of Appeal is the terminus for all litigations concerning trade disputes, outside of criminal matters. And this is not a criminal matter emanating from National Industrial Court.
So, with due respect, in other words, you are saying that the decision of the Court of Appeal is not harsh, that is fair. Because you also recall that in this particular case, the second ground of appeal, was removed. The applicants said, okay, yes, we don't want...
No, they abandoned the application for stay.
Their second appeal, the stay of execution. They removed it. And in the ruling by Sir Biobele Georgewell, JCA.
Georgewell JCA?
Yes. He said, look, okay, it's within their rights to do so, and it will be granted. Okay, so what options now? You have referred to it, but I just want you to make it categorical. What options now are available to the applicants in this Court of Appeal case? The Court of Appeal having, a place in our juridical system.
Well, the option open to the ASUU is to take the benefit along with the burden of that leave to appeal. I've explained that appealing from NIC decision is not automatic ordinarily. The decisions are normally final, and you can only appeal except for breach of contract with leave. And that leave is normally not by the National Industrial Court. It can only be granted by the Court of Appeal. Now, if they want, that means the court was invited to exercise a discretion. Discretion, unlike principles, are within the bosom of the court to apply, taking all circumstances into account. And the same fact presented before the same judge may not attract the same outcome depending on the circumstances. Now, if they wanted the court, as they did, to grant them opportunity to test the decision of the National Industrial Court, and not as of right, but with leave, then they must pay the price. And the quid pro quo for the leave to appeal in this instance is that they must first call off the strike within the window allowed by the order of court, which is 7 days. And I don't think that the problem with ASUU and FG is something that even if the call off the strike cannot be addressed, and even if it's going to be addressed, it's going to take a long-run dispute that we must all sit down and apply common sense to. It's not, like I said, strike itself is not the dispute between the parties. Strike was an instrument to force the other parties to come to a negotiating table and agree on something fair. So we should not prioritize strike over resolution of the real dispute between the parties.
Okay, let me put it like this, Owonikoko.
But if they don't call off within 7 days, then the order is vacated.
Okay,
yes, please.
Let me put it this way. The court said that there is no inherent right of appeal. So, what it means, as you have just stated, can you help us make it clear that if ASUU does not respect the ruling of the Court of Appeal, it cannot go any further? And that we expect that within the next 7 days, that the universities will be reopened. However, let me ask you, is this a ruling on the basis of public policy, public interest, rather than the constitutionality or the statutory implications that the court talked about?
Now, this is not a public policy judgment. It's a decision that is rooted in both the Constitution and the law regarding trade disputes and trade union activities. Why? I happen to know that in 2005, the trade unions law in Nigeria was amended to address some of the disturbing aspects of industrial relations that seem to bog down the economy. And in that law, the issue of strike as an instrument to protect interests as against rights was addressed. Where we are today is that parties have set up bodies, the court has ordered that parties should go and negotiate. There is no right to strike in Nigeria, but right to strike is tolerated up until when the matter gets before the court. So already, the moment the matter got to court, the right to strike is suspended, pending the outcome of the decision. But if the decision of the court comes and parties are still aggrieved, they can generate a fresh dispute that will entitle them to even use strike again as an instrument for bargaining their right. So if you look at the Constitution under Section 254C, which vests the National Industrial Court with exclusive power to address issue of industrial relations, and also the Trade Unions Act amendment as amended in 2005, it will be obvious that the court actually invoked what is called the anti-strike injunction law that is embedded in the 2004 Act. Under that Act, unlike what used to happen, you can actually approach the court, either as an employer or an employee, simply to stop one of the parties from embarking on what is not a legally tolerable strike. And you make your case, and that order can be granted pending when you exhaust all the avenues for dispute resolution. It was never the case before. And that was why, if you recall, under General Obasanjo's presidency, each time NLC was embarking on trade disputes to press matters of interest, the government was always struggling to look for one form of legal way or the other to stop it. You see them obtaining an order in Abuja today. If they cannot get it, they come to Lagos, National Industrial Court, Federal High Court. In fact, they hardly ever go to National Industrial Court. If you recall, they will either go to State High Court or Federal High Court, because the principle of adjudication in National Industrial Court is that if parties are on strike, they must cease strike once the matter is before the court. So government used to go to Federal High Court, FCT High Court, or State High Court. That's why you have the case of NLC and federal government and all those cases between 2002 and 2003 or 4. Then this law was enacted to actually create a legitimate basis on which you can actually approach that court to stop an industrial action. And that actually is what gives the court decision to do what I believe it did, subject to how the Court of Appeal will interpret the exercise of that discretion that was granted by the Industrial Court.
Okay.
There is an anti-strike injunction law in Nigeria now.
I get your point, but you also recall that there's a University of Ife case where the court in Ibadan, sitting in Ibadan, I think, appeal court, said that, look, people have the right to strike under the principles of collective bargaining if their labor rights have been, violated. That case is there, but I don't want to argue law with you. This is not about legalese.
No, but you are right, sir. No, you are very correct. That's Section 6.4 of the Trade Unions Amendment Act. It says conditions. In fact, for you to go on strike now by that law, there must even be a ballot of your organization saying that you agree to strike. Majority must agree, and then you must exhaust the procedure, failing which you can go on strike. But once that matter now, escalates and is now before either Industrial Arbitration Panel, Tribunal, or National Industrial Court, the first thing that parties must do is to cease industrial action, whether lockout or strike.
Okay.
There is right to strike.
Okay, ASUU has now
within
said...
a defined parameter.
Okay, ASUU has now said they are going to consult their lawyers and they will take a decision. So it looks from the arguments advanced by you, that ASUU has no other option than to respect the rule of law, because the position of law at the moment is the position that has been taken by the Court of Appeal. Does ASUU, are there other options that are available to ASUU?
Well, I'm not too sure that they have too much of room to wiggle out of calling off the strike as at now. And I'm gratified that they have one of the best trade union lawyers, advising them in person of Mr. Femi Falana SAN. Incidentally, both of us trade under the same leading Nigerian #1 labor lawyer, Mr. Alawa Kabashorun. I was under Mr. Falana's understudy in that chambers. And practically all trade unions in Nigeria, we had the opportunity to work with them. So I'm sure he has done his best for them, and he has forced government to sit down to do genuine negotiation with them. At this stage, I don't see that Mr. Falana will advise against disobeying the order of the Court of Appeal, especially when he got there, asked for a discretion in his favor, and it was exercised somewhere in his favor, got a leave to appeal in an area where it's very difficult for the court ordinarily to grant such an indulgence. I think we can be hopeful that ASUU will be properly advised to call off the strike within that period, and then they can have their appeal entered at the Court of Appeal.
Okay,
have their day
again, let me thank you very much for joining us on this program today. We have had very important legal issues this week. ASUU is one. The second one,
my pleasure,
that I would like us to talk about briefly because of its importance, is a matter in Rivers State, where the House of Assembly, the Ninth House of Assembly in Rivers State, decided that they would de-recognize Celestine Omehia as governor of Rivers State. The same Celestine Omehia that same it was the 8th National Assembly, recognized and allowed privileges and benefits as a governor, in contradiction to the ruling of the Supreme Court in 2005, 2006, thereabouts. Maybe I get the dates wrong. What do you think of that matter, considering the fact that the Supreme Court has also reversed itself in Modibo versus Mustafa, in the Ombagbadue case, and also if you look at the rules, Section 141 of the 2010 Electoral Act stated very clearly that for you to be a candidate, you have to be in every part of the electoral process. In other words, the ruling is Celestine Omehia versus Rotimi Amechi, have been declared in law as bad law. So what is the legality of this step that has been taken by the Ninth Assembly of the Rivers State House of Assembly?
Sometimes, I think in my own language, there is a proverb that there are many ways of catching a snake. You could use a wrapper to fold his head, you could use a hammer to whatever. What has happened is that the State Assembly has come full circle back to where they ought to be. Permit me to say that I was one of the 3 counsel that handled the Amechi case at the Supreme Court, led by Fagbemi SAN, Rikitafa SAN, and myself. And the judgment of the Supreme Court was that in the eye of the law, from the very beginning, 29th of May 2007, the real winner of the election on the platform of PDP for governorship in Rivers State was Right Honorable Rotimi Chibuike Amechi. And that therefore, forthwith, that very day, he was recognized as the governor right from the very beginning of the tenure of that regime. And also, for that same reason, when the time comes for Amechi to go for second term, the question arose as to whether he had exhausted his 4 years. I was also involved in the case litigated to determine that point. Because if Amechi was sworn in October when judgment was given, whereas the swearing was 29th of May you will remember, 2007. Then he ought to have contested his second term in October 2011. But the argument was made that in this case, it was the same party, and the court has said that the candidate who won the election in the eye of the law was Amaechi. He did not have to defer his own re-election till October, like all other off-season elections. And that's actually today. Ordinarily, governorship election in Rivers has continued to be held at the same time as all other general elections, unlike places like Bayelsa, Ekiti, Osun. So, from day one, Omehia ceased to be a governor as a matter of law and as a matter of fact from the moment judgment of Supreme Court was made. Why did the State Assembly now make that resolution in 2015? I cannot tell why they did that. But it's obvious that they were, by doing so, delegitimizing the judgment of the Supreme Court, which was the final and binding judgment that determined the status of Omehia. If in 2022, the same parliament now, came back to their senses and decided to do what is right, regardless of the politics involved, I think they have gone the right way. Because the idea of just, creating a monument for people all over the place, burdening down the state's treasury for no reason, is something that we need to address, especially given the policy of our economy now. I was shocked to hear that even as a person that the court has said was never a governor, State Treasury has been, benefiting him to the tune of about 700 million over the course of the past 8 years.
No. With due respect, Owonikoko SAN.
Yes.
What I'm saying is that the Supreme Court itself had reversed itself, saying that the decision in Omehia versus Amaechi was bad law. They did so in Modibo versus Mustafa, Yobe North and South Federal Constituency case. They did so also in Omagbadue case. The Court of Appeal has also done a plethora of cases in which the Court of Appeal reversed itself, did not reverse itself, said that it was bad law to say that, okay, if you are the candidate of the party and you are not the candidate in the election, you can become the governor. And Section 141 of the Electoral Act 2010.
Can I address that?
Okay, go ahead. Address also Section 141 of the Electoral Act of 2010.
Amaechi's case was not... Can I address that?
Please go ahead.
Amaechi's case was not fought on the basis of 2010 Electoral Act. It was fought on the basis of the previous Electoral Act. And it was in response to the decision in Amaechi that they amended the Electoral Act in 2010 to now say that you must have participated at all stages of election before you can be returned as a winner, even through the court. As at the time Amaechi judgment was given, there was no such provision either in the Electoral Act or in the Constitution. So the court proceeded on the basis that, as at that time, it was the party that was elected in any event. There is no right to independent candidature. But to address what happened in Amaechi's case, in 2010, the Electoral Act was amended to now say that for you to be returned, regardless of how the dispute arose, you must have participated at all stages of the election. And that, in my view, still does not prevent the situation in Amaechi from arising. Otherwise, you will not have what happened in Zamfara, and you will not have what happened in Bayelsa. Now, this provision is now, even in the Constitution itself, to show that they needed to, what has happened is that the law has been amended, but the law that guided the provision as regards Omehia State was the Electoral Act before 2010, not the Electoral Act 2010 that says you must have participated. And if you look at those cases did not arise, those cases where the Supreme Court made those, they actually reversed themselves because they were between the tribunal deciding your status and a court taking a pre-election matter. There are two different things.
Okay.
So, in pre-election matter, if you didn't participate in the process, you cannot be returned. You must have either, even in an opposition party, you must have participated. Omehia did not participate as far as the law was concerned. Amaechi had been seen as the candidate right from the beginning, and they were warned in 2007 not to field another candidate. They refused. They then removed Amaechi as a member of the party so that they can take the carpet off his feet so that he will not be a governor. Supreme Court had to now reverse them, that the entire litigation before them will be rendered useless if the party on its own can take a step and then deny the court of judgment to take a decision. So that's the distinction.
Okay, Owonikoko SAN, I cannot argue the law with you. That's what you do on a daily basis. I sit here every day and...
no, it's just that I happen to have some advantage of being involved in some of these particular cases, so I cover the fact a bit here. You are doing a fantastic job on that place. I don't know sometimes whether you are still a lawyer, you are still a journalist, or you are a lawyer now, because you are doing a good job of a lawyer.
Not a problem. But I've raised the issues, and I hope that the legal community will look at it. Whether or not the Supreme Court reverses itself. It cannot reverse itself in a specific case, but it can reverse itself in other cases. And I've cited some of the instances in which the Supreme Court reverses itself with regard to the legality of Omehia versus Amechi case. And then there will be questions about the legality of the decision that has been taken by the Rivers State House of Assembly. However, let me ask you, is there any wiggle room available for Celestine Omehia? Is it possible that another House of Assembly will come up in Rivers State and then say, look, the decision taken by the 8th Assembly, 8th Assembly was wrong, and then decide to reinstate the privileges of Celestine Omehia?
Well, my answer to that is that from the very foundation of their decision, they had no right whatsoever to second-guess or superimpose their view on the judgment of the Supreme Court. 287 of the Constitution is very clear. All authorities and persons are bound by judgment of the Supreme Court. And what they were doing actually is what is called legislative judgment. They ought not, by resolution, be defining rights of people. Their right is to make law and probably oversight execution of law. It's not to define people's rights, which is what they have done. In this case, Omehia has an opportunity, for instance, to say that the rights that are accrued based on their initial representation to him can no longer be taken away. But going forward, knowing that he has a challenge of justifying his continuing enjoyment of those benefits despite judgment of the Supreme Court in Amechi, I don't think there is much to say in the civil going forward. But for what he has earned, it will be difficult for anybody, any court, to say that he earned them illegitimately, because there was a color of legitimacy when he earned the money. The parliament of the state that was voting money, appropriating money, voted money. So the appropriation itself, which was never challenged, already legitimizes the monies he has earned up until now. Because even for you to earn a kobo from government as a former governor, there must be a legislation that authorizes it, and the money must be appropriated. I want to imagine that all the earnings enjoyed by Mr. Omehia from 2007 till date were backed by appropriation and is entitled to. You have to first go and reverse those laws that entitle him to the money before you can ask him to pay the money back. But going forward, I think it may be difficult for him to now assert that right to continue enjoyment of those emoluments of office of governor that the Supreme Court said in the eye of law he never occupied.
Well, thank you very much, Owonikoko SAN, for joining us on this Live, the Sunday Talk Show. Thank you very much indeed.